Okay, I think we're probably ready to start. Sorry, we're running a little bit late as usual. Some slight tech issues, but all sorted now, which is good. Hello to everybody who's joined us online this evening. Very nice to have you. As always, thank you very much to the Grantham Research Institute for hosting us again this evening. It's always such a pleasure for us to be here. Always very grateful for your support, Emily, because you've helped us so much with all of the facilitating and setting everything up this evening. Just in case the fire alarm goes off this evening, which I'm sure it won't, but in case it does, please can we all exit through this door or this door at the back. The stairs are by the elevators. If you could take the stairs and not the elevator, that would be great. If anyone needs a drink, there is a kitchen just behind here. Please fill up your water bottles. I think there's a couple of glasses. If you use them, please could you wash them up and dry them up just so that no one from GRI has to do that later. Yeah, without further ado, welcome. Thank you very much for joining us. In case we've got anybody new this evening in the room or online, I'm just going to give a quick background about LBF. I'm Riley. I'm one of the members of the Stewardship Committee. Legal Voices for the Future is an organisation run solely by a group of early legal career practitioners. Our objective is to get all of the young lawyers, barristers, in-house lawyers in a room together to talk about the issues that are facing everyone today, but also particularly poignant for legal practitioners, which are the climate and biodiversity crises. They're two of the most pressing issues facing the whole world today. And our aim is to do this by having these monthly knowledge sessions, which I'm sure so many of you have been to before, but if you haven't been, the topics are vastly ranging. Today, John's going to be talking to us about human rights and climate change. We've had sessions on nature rights. We had a session in September about animals and international wildlife crime, and we're always looking for new presentations. So if anyone ever has any ideas, please do approach myself or any other members of the committee. Yeah, essentially our knowledge sessions are broken up into 3 parts. We normally have a presentation by a speaker. So again, today that was John. Thank you very much in advance, John. Then we normally have a panel session. Today we're joined by Joana Setzer. Thank you very much for spending your time with us this evening. We're all very excited to hear from you. And then the final part of our session, we have a creative content element. And that is really for our members to be able to get together to talk in an informal setting about something creative that will join us all together. And it's a safe space for us to all share reflections, thoughts, emotions about these things and just get together as a group of passionate young legal practitioners. So yeah, without further ado, I'll hand over to John. Thank you very much.
Thank you very much, Riley. So hi everyone. My name is John. I'm an associate in the Linklaters ESG team. And today I'll be talking about the human rights considerations in sustainability regulation and the impact that this could potentially have on climate. Sorry, IT issues. So in terms of what we'll be covering today, today's presentation will be broken into four main parts. So I'll start by really setting the scene and trying to contextualize corporate responsibility within the human rights and climate change space. After that, I thought it would be helpful to give everyone a quick introduction to the area of business and human rights and what this really means and what it entails. And after that, and that's when we start to really dive into the regulation, where I'll look at the EU regulatory framework and we'll talk about how human rights has really been integrated into some of these regulatory regimes that we've seen coming out of Brussels. I'll then conclude with some short takeaways on what this really means for climate action and give everyone a few food for thought to take away into your evening. So now, setting the scene. So it is well established that climate change impacts are human rights impacts. We've seen this gradual expansion and the recognition of the nexus between these two areas over the years. For example, in the Cancun Agreement in 2010, we saw the first recognition of the connection between climate impacts and adverse human rights impacts. This was then acknowledged in the Paris Agreement in 2015 and really had become a core part of many climate campaigns and within the NGO discourse. In 2015, we also saw the UNEP state that climate change is one of the greatest threats to human rights in our generation. Since then, and most recently, we've seen this really feed into judicial rulings at both the international and the domestic level. So some of you might have attended last month's session on that's presented by Sarah, and where they talked about the landmark ruling that came out of the European Court of Human Rights, Viren Tima Signorinen versus Switzerland. And now we have similar cases looking at the connection between climate and human rights going on in the Inter-American Court of Human Rights and also coming up at the ITJ. At the domestic level, the Indian Supreme Court ruled last month that the right against climate change was part and parcel of the right to life. As you can see, this is a very broad topic, and there are some examples of all of the different intersections and different angles that we could dive into if you wanted to really discuss human rights and climate change. So for today's session, given our time, given the time limitations, we'll really be zooming in on corporate accountability and how corporate accountability for the human rights impacts of climate change are and can be shaped by regulation. So the main argument that I'll be trying to put across today is that the expansion of human rights in regulatory regimes that we see in the EU has really opened the door for a discussion on corporate accountability for these adverse impacts. So we saw this connection first made in the lawsuit filed by Milieu Defensie against Shell in the Netherlands, where it was held that Shell had a duty of care in preventing dangerous climate change. And a key component of this ruling was actually the incorporation of the UN Guiding Principles on business and human rights into the Dutch duty of care. And since that landmark ruling, we see the ESG agenda continue to roll forward, and the expectations of all corporates continue to get pushed higher and higher. So now that we've laid the groundwork, now it's a good time to really take a step back and give everyone a quick snapshot of this amorphous concept known as business and human rights. If you look at the concept of human rights, the responsibility to protect and uphold human rights has traditionally sat with state entities and public bodies. So it sits very squarely in the realm of public law. So this is implemented through international treaties such as the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. Whereas if you were to look at it on the other end of the spectrum and look at how human rights tie into private actors, business efforts to address human rights have really been led and guided by various soft law initiatives, which do not have legally binding force. And for those of you who might be familiar with these soft law initiatives, some of them, such as the OECD guidelines for multinational enterprises, do have some ways for claimants to bring complaints against companies. And so this would be through things called their national contact points, which are forums established in OECD member states. But the issue here is the rulings issued by these national contact points, similar to the soft law concepts that underpin them, are not legally binding. So really the main point of these regimes and the main pressure to really compel corporates to comply is through reputational risk rather than hard law implications. However, as you'll see from the ruling in the Dutch court that I mentioned earlier, we've seen these soft law concepts slowly beginning to creep in to regulation, government guidance, and judicial decision making. So a lot of people like to talk about the crystallization of soft law into hard law. And the EU in this respect has really been leading the way and driving the agenda by really incorporating human rights and soft law considerations into the key legislative infrastructure of the EU Green Deal. So if you go on to the next slide, you'll see that the three buckets that I'd like to talk about would be sustainability reporting, mandatory human rights and environmental due diligence, and classification and labeling. I'd look to expand on how we see human rights incorporated into these regimes and how these might then feed into climate action. For today's presentation, I'll only be focusing on the CSRD, the CS3D, and the Taxonomy Regulation. But if you'd like to find out more, I'd be very happy to have a chat after this. So starting with the CS3D. The CS3D is really an unprecedented piece of regulation. And some of you may have heard of it before, but if you haven't, what it does is it requires companies to conduct mandatory human rights and environmental due diligence to identify and assess human rights and environmental impacts in their own operations and also in their chain of activities. So this sits alongside some of the existing and upcoming product-specific regimes that you saw in the previous slide, which cover things such as conflict minerals and deforestation-prone commodities. But what sets the CS3D apart is that it applies across an entire business's operations. Prior to the CS3D being passed earlier this year, we have had a few individual member states introduce their own supply chain due diligence laws. We have the German Supply Chain Due Diligence Act and the French Duty of Vigilance. But the CS3D really looks to push the envelope by introducing this EU-wide regime. The sheer ambition of the CS3D and what it hopes to achieve was really evident when we looked at the very heated debates that we had in the lead up to it being passed. I think it was in May this year. At that point, many people and many commentators actually thought that the regime was dead in the water because there was such strong pushback from key member states such as Germany and Italy, who thought that the administrative burden that this would put on companies was not feasible economically. But despite all of this pushback, eventually the CS3D managed to make it into law, albeit with some significant concessions. However, even in its final form, I think the CS3D will still have very far-reaching implications through the introduction of this very wide-ranging human rights due diligence regime. Importantly, it has extraterritorial effect. So it doesn't apply solely to just EU companies, but also applies to non-EU companies that do business in the EU and generate a certain amount of turnover within the common market. This in fact creates almost a condition of access to the EU market. So for us, lawyers practicing in the UK, a lot of our clients who might be headquartered in the UK or overseas that have significant operations in the EU will similarly have to comply. And most significantly, and I think this was quite a key point of contention in the negotiations, was the introduction of the penalty regime. So the CS3D introduces both a public penalty regime and a civil liability regime. So companies that fail to comply can be subject to public enforcement, which can come through sanctions and fines, but they can also be exposed to civil liability. So what the civil liability regime does is that companies that fail to comply with these due diligence requirements and fail to take appropriate measures to identify, assess, prevent, and mitigate human rights impacts may be open to civil liability from impacted individuals. This applies not just to the company themselves, but also to impacts and damages caused by their subsidiaries. So for some of you who have been following the business and human rights space might think that this sounds quite a bit like parent company liability, and in fact it is. So the CSDD does really, by introducing this new regime, opens up the potential to shortcut quite a few of the hoops that you would historically have had to jump through to establish parent company liability by drawing this straight connection up to the parent company for impacts caused by subsidiaries in their corporate structure. Directly relevant to climate, the CSDD also introduces a requirement for companies to develop and put into effect a transition plan that is aligned with 1.5 degrees Celsius. Although it's not really clear why this was shoehorned into the CSDD, it is still quite a big step in that it's the first instance of the companies being mandated to develop and publish climate transition plans. And now just going on to this next slide, this shows kind of a quick overview and snapshot of the core elements of the human rights and environmental due diligence requirements under the CSDD. So the scope requires companies to identify actual and potential impacts in their own operations, subsidiaries, and also the chain of activities. And chain of activities is quite a broad concept, which includes both your upstream and downstream business partners. So really looking all the way down the supply chain. On the left of the screen, you'll see the 6 steps that form the basis of the human rights due diligence obligations. I won't go into too much detail on these, but I think I would like to draw your attention to, I think, the tree in the bottom corner, where companies are required to identify adverse impacts of conduct due diligence. And if these are identified, or if they identify the risk of a potential adverse impact, they then have to take actions to prevent, seize, or minimize these impacts. I think the last point at the bottom of the screen is remediation, where if you directly cause the infringement of someone's human rights, you are required to remediate. And if you're familiar with the UN Guiding Principles, you might see that these 6 steps actually very closely mirror the expectations under this soft law framework. Now, just going on into the next bucket of regulation, sustainability reporting. The CSRD is a similarly landmark piece of legislation in that it introduces new mandatory reporting requirements for a wide range of companies. And similar to the CSRD, it will also have extraterritorial implications. And under this regime, companies are required to report on a very wide range of environmental, social, and governance topics, where they have to identify impacts, risks, and opportunities in both their operations and their own value chains. The topics that have to be covered are dealt with in detailed reporting standards known as European Sustainability Reporting Standards, or ESIs for short, and cover topics ranging from climate change to biodiversity, to social topics such as workers in the value chain and affected communities. A key facet of the CSRD that I really want to draw people's attention to today is the concept of double materiality, which was a fundamental change introduced by the CSRD. And for those of you that aren't familiar with double materiality, you can see on the slide that it consists of 2 core components. It includes financial materiality, which is the financial risk that something would pose to your business. So this is really traditional financial reporting that you would be familiar with and are quite common in classic financial and corporate disclosures. But what the CSRD then includes is the concept of impact materiality, which looks at the impacts that you as a business might have on people and the environment. So this is it's a new concept. It isn't a brand new concept and had been around in some existing voluntary frameworks such as the Global Reporting Initiative. But the fact that this is being incorporated and included as a mandatory requirement is quite a significant step. And the concept of double materiality has been subject to quite a significant amount of debate, and we've seen discussions and speculation over whether whether reporting done at this scale could be included in other jurisdictions such as the US and the UK. However, to date, there hasn't been a lot of political appetite to kind of push the boundaries that far just yet. So in terms of the connection between human rights and climate change within the CSRD, we've seen human rights get really kind of incorporated into the social standards. So for example, if you were to look at the ESRS for reporting on your own workforce, it states that the objective of the standard is to enable users to understand the extent to which the undertaking aligns with or complies with international and European human rights instruments and conventions. Companies are also required to disclose their human rights policy commitments and how they ensure they comply with these. However, what the ESRSs do not do is actually draw a connection between climate and human rights impacts. And these topics are really dealt with in their own individual reporting standards with minimal overlap. The only recognition of a potential connection between these two standards is that the transition to a low carbon or carbon neutral economy might have impacts on your employees and workers in the value chain. So it really only looks at it in the just transition and doesn't acknowledge that in some instances, human rights or climate change impacts would have adverse human rights impacts. However, notwithstanding this lack of a connection in the actual regimes, I think as companies continue to do their materiality assessments under the double materiality assessment framework and continue to try and identify the impacts that they might have on human rights, and also as the impacts of climate change become more severe and more prominent, it may be hard to continue to treat these these two areas as distinct areas of impact. I mean, especially so as society and courts start to draw a clearer connection between the two concepts. The last bucket that I'd like to briefly talk about and to really close the circle is on classification and labeling. We have the EU Taxonomy Regulation that, in essence, is a classification regime that helps, that sets out an EU-wide framework for investors and businesses to identify what constitutes a green activity. So whether or not an activity is environmentally sustainable. The taxonomy regulation covers 6 different environmental objectives, which include climate change mitigation and adaptation, biodiversity, water, circular economy, and pollution. So in order for something to qualify as a green activity or a sustainable activity under the taxonomy, there are three steps that have to be fulfilled. So firstly, it has to substantially contribute to one of the environmental objectives, so climate mitigation, for example, and it has to do no significant harm to the remaining 5. And lastly, and most relevant to today's discussion, is that it has to be carried out in accordance with certain minimum safeguards. There has been very detailed guidance on how you substantially contribute and how you have to do no significant harm, and this has been set out in very detailed and highly technical regulatory standards. However, what we've seen so far is that guidance on minimum safeguards has been fairly limited, and to date, companies generally have treated this as a screening exercise to ensure that companies that they invest in haven't been identified for having severe human rights issues in the operations or supply chain. However, I think with the CSRD and the CSDDD coming into force, there is potential for there to be heightened scrutiny on what these minimum safeguards require. And there's room to consider whether or not, assessing whether or not you are in alignment with the OECD guidelines and the UNGPs can be completed solely through a simple screening exercise. So now that I've given everyone a bit of a kind of lay of the land of the regulatory landscape, I think that the next question is really where do we go from here and what does this mean for climate? The EU regulatory package has really laid a blueprint for how corporate accountability for human rights can be integrated into hard law and regulation. With the EU taxonomy and with regimes such as the SFDR, we see much stronger scrutiny of what you consider to be green. And this scrutiny and focus on concepts such as the minimum safeguards will hopefully provide important guardrails for the just transition to a low carbon economy. And with the CSRD, we see a whole host of additional requirements that require companies to actively assess and disclose their external impacts. The CSRD will bring about unprecedented transparency about the sustainability of companies and will force companies to really take into consideration impacts that they previously may not have considered as part of their business planning. And I think importantly for the climate action space, the CSRD will provide stakeholders, so both NGOs, shareholders, and customers, with much more information on companies, and such that they'll be able to use this information to hold companies accountable. And most importantly, we have the CS3D, which really introduces these very wide-ranging and thorough mandatory due diligence requirements that creates new levers for driving corporate change. The CS3D really goes beyond pure disclosure requirements and introduces these binding obligations for companies to take steps to become more sustainable. By introducing these due diligence obligations and making companies consider the human rights impacts, this opens the door for arguments similar to those made in Milieu Defensive versus Shell and to be raised in other forums. And if you want to see an indication of where things might lead, I think some helpful reference can be made to lawsuits that we've seen brought under the French duty of vigilance, where we've seen cases filed against entities such as Total and BNP Paribas, where they've been accused of failing to uphold their duty of care, or failing to uphold their duty of vigilance by not taking into account the human rights impacts of climate change. On this point, I think this is a very good segue to the next part of our session, which is a fireside chat with the one and only Joana Setzer.
Thank you, John. That was such a great talk, so clear and comprehensive. I have to say, I really enjoyed it. Yeah, I almost forgot we had this part here. I was enjoying so much, but bring it on.
Thank you. Yes, I'm very glad to be joined by Joana Setzer today. And I thought I might do a quick introduction so everyone on our online audience and in the room get to know, who Joana is and what she does. And Joana is an associate professor, a Professorial Research Fellow at the GRI, who are our kind hosts this evening. And her main expertise are the areas of climate litigation and global environmental governance. And I think you've been involved in the Grantham Research Institute Climate Change of the World project in 2013, which, for those of you that don't know, is the most comprehensive global resource on climate change, or climate policy and legislation. Joana is also a contributing author to the Working Group 3 of the IPCC's 6th Assessment Review and regularly advises many international governments and NGOs on climate policy. Thank you again for blessing us with your presence, Joanna. So given your expertise in climate litigation, I think a question that I wanted to ask is, we've seen this shift over the past couple of years, which some people have termed the human rights turn in climate litigation. And I've briefly referred to this a few times in my presentation. I was hoping whether you could tell us a little bit more about this shift and how it has shaped the climate litigation landscape.
I think it's a good question to ask because you already this is on. Maybe yeah. That one seems so right. Yeah, I think that one is right. Yeah, I think that one seems. I think everyone. Can you hear well? Yeah. Okay. Good. So what you are presenting, I think it's very much speaks to the lawyers in the room and how they will have to respond to these changes in the regulation. Actually, I do have a question ready for you after for Q&As, because I used to be a lawyer long ago, and so I'm thinking what kind of questions your clients are asking and how you reading these regulations and following the litigation, how you are advising your clients. But I think now that I am not anymore there on the front line of being a litigator myself, I really enjoy this. I call it privilege of being an academic and just observing what's going on and commenting on what's happening. And I think this is where this rights turn in climate litigation comes from. In the literature on climate change litigation, the mothers of this field, Harry Ozowski and Jackie Peel, in 2017, I think, 2017, published this paper called The Rights Turn in Climate Litigation. So at the time in 2017, we barely had any case. They really had this vision that this is where it was going, and their bet was absolutely right. So in 2017, they said, well, we think this might be going in this direction. Climate litigation will be merging with human rights. And then in 2021, together with a colleague, Annalisa Savaresi, I wrote a paper where we identified for the first time all the rights-based climate cases, which at the time were 100 cases. And we understood what were the different types, and it's a paper, like a mapping paper. But if you look now, the New York University database has over 300 rights-based cases, and these are just the ones we know about. And it's really happened that the idea that you would see these areas coming together really has happened and has evolved in amazing ways. So I would say that the encounter between these two areas have reshaped climate litigation. It's hard to imagine what would be of climate litigation without the human rights turn. Could be an interesting exercise. Try to delete all of that and think what it would have been. There's been a huge step, I think, thanks to really this encounter. And so you asked me how I think this has shaped climate litigation, and I thought of four ways in which it has shaped, but I won't go into details because I'm aware I have not much time to cover this. So the first way I think human rights have shaped climate litigation is the spread and how is it inspired more cases. So the notable cases of the early days, Rugenda, and of course also Legari, then how it has spread into Neubauer and even the not completely successful Sharma case in Australia, all the way to the recent Klimasirnin case and also the Klimatskat in Belgium. All of this phenomena of one case sparking ideas for lawyers, that's really truly fascinating. So it had this impact of creating this inspiration, and the more successful the cases are, the more lawyers in countries where you hadn't seen this type of combination started bringing and thinking, okay, how can I do this in my jurisdiction? The second impact, I think, is this the kind of the pushing the legal theories. So it has pushed the idea of standing to bring future generations, the children, the unborn, many of these who didn't have rights to vote or who would never be filing a case themselves, but who were then part of this litigation. It has also, I think, helped bringing this sense of urgency, because so many of the cases and the science have been repeating again and again, this is urgent, we have to do something about it. But I don't think that any of the cases, other than the human rights, have been so effective in bringing that sense of urgency. And at the same time, I usually say the human rights have been an upgrade for the climate cases, because one thing is for a judge to say, this is urgent, you have to do something about this because the government is not doing. The other thing is to say all of that and say, and if what we're talking about here is a violation of human rights, including the right to life. I imagine the moment a judge is put something like this, okay, this seems important, let me see if I have to do something about this, right? It really upgrades the case. Of course, there are still those challenges that are challenges for the litigation, the causation issue, separation of powers. And we see in these cases mixed results. Some get through quite easily, some have to really work hard to get through. But it's interesting, I think, to compare, and we've done some analysis, and other colleagues have done, to see separation of powers, isolate that. How has it been easier and harder in different jurisdictions? The last issue that I want to bring in terms of impacts is one that you touched upon, which is how human rights in climate change started in cases against governments, the ones that we usually call framework cases, the ones I mentioned, and it has then traveled to litigation against corporates. That was also amazing, when it was already quite extraordinary that agenda won, and then when you saw soon after the same idea of a duty of care in relation to governments being brought in terms of a duty of care in relation to a corporation, that was truly extraordinary again. So you see how there's this learning between the cases against governments in regards to the cases against corporations, and how this is being tested in the OECD complaints or in actual litigation. So I think altogether, I feel that there's been a shift, that the two areas being brought together in law, because of course that's a legal fiction, right? It existed already that climate change is a human rights issue, but it was not recognized in law. So we're talking about our legal fiction here, but it has made climate more personal, more urgent, and probably more successful. Although, of course, in the long term, we still don't know what these cases are going to be in 5-10 years, but in terms of victory, it's been a very successful story.
That's really interesting. Thank you. And so while you're, I think you talked about how we've seen human rights cases really, play such a big role in shaping climate litigation and forming the backbone of many new cases that we've seen being brought. So in my presentation, I talked about how we've seen human rights arguments, or human rights factors get woven into regulatory regimes, which introduce new obligations for companies to basically respect human rights, which previously wasn't something relevant for them. So do you think, how do you see this really impacting the climate litigation trends, and do you think this would drive or change corporate behavior?
So I think I would break this question into two. One is how these cases have impacted general trends in general climate litigation, and then specifically about corporate behavior. And the story about this impacting general global trends is one that I think it's important to make, because it's something we often speak at GRI, that these cases don't exist in isolation. It's not just about one case. Ian and I had many discussions like this, that the cases against an oil company is not just a shell case. It's not the greenwashing case. This is a concerted effort that when possible, and where possible, will go more towards one or other direction. So these cases will, I think, mean broader impacts. It will mean probably more cases, because there is this cross-fertilization effect. It will mean also that we've paved ways for plaintiffs to bring cases. So the discussion in the Prima Syrian, in whether it's individuals or organizations, all these standing questions that have been resolved in many of these cases mean, in most cases, that you've expanded the standing. So I think one of the impacts generally is you've allowed for more standing, more cases. And finally, one that we haven't seen much yet, but I think I keep thinking it will happen, is more cases on adaptation. Because it's been, well, the majority of cases have been on mitigation. That's something that has been like this from the start. But we also know that there are more impacts now, that we have better ways to track, and also that the losses are growing. So I think it's a matter of time where we see human rights being used more for adaptation. Legari did this in 2015. We've barely seen any case like Legari after. You have many adaptation strategies that are not being put into place. Why aren't these being litigated on human rights grounds, right? I think it's still a bit of a mystery that I imagine we'll see increase and more impact. Now, particularly regarding corporations, the impacts for me are, first, corporations now are not just afraid of the actual litigation, but of the risk of litigation. And that's super interesting because that changes behavior of companies that haven't been litigated against already. We have a paper that is, as from today, we have received news that has been accepted in Nature. And the paper shows that litigation against major carbon emitters impacts their share prices. So you have a reputational damage, you have that reputational damage even being possibly measured in drops in share prices. So that means that corporations will try to do better. So they will invest in risk assessments, in climate risk assessments. They will have more targets. They will try to mitigate when possible. They will be hopefully more proactive, just out of fear of being involved in litigation. At the same time, you mentioned the CSDDD and CSRD, and these are likely to not only require more, well, they will require more disclosure and more assessment, but also potentially more litigation. Where I think it's really important to be careful is that we have a tendency to, well, the NGOs, particularly litigating, have a tendency to go against the announcements, the advertisement. So that what is out there and is not being delivered, which makes sense. It's been announced, it's not being delivered. But I also think it will be really important to focus on the companies that have been very quiet, those that are not disclosing, not being proactive. So maybe there will be still more of a balance between these two, the strategies against the quiet ones and the active ones, hopefully. And another point, I have two more that I thought about. One is in terms of changes in governance. So I think this litigation and the risk of litigation is and will more result in directors and executives knowing that they have to be on top of things and make decisions and investments that are aligned with what the science is saying. And it's not that it's the science and the law. It's not the NGOs, right? It's very much official and proven, and therefore it's not justifiable for directors and executives that they are unaware, and for lawyers. So the risk also applies to you guys. So I think this also means in terms of opportunities, new roles. This is probably one of the reasons why you're here. You're trying to be better at advising your clients, and I think that creates new jobs and new expertise, which is important and necessary. The last 2 points. One is in terms of lobbying. We know that companies lobby, NGOs lobby, everyone lobbies. And what's happening now, I think there is more scrutiny regarding what you say you're doing and what you're lobbying. And there is already a case, for instance, brought by Church of England against Volkswagen, challenging that discrepancy between their announcements and their lobbying. And then finally, one area that is very important, I saw she is here, and I always think of our work with insurance, because that was the first time I was exposed to the insurance sector, and how some actors in this constellation are crucial, and the insurance sector is one of those, because it's not the obvious high emitting company, but it's the one that insures those companies, that invests in those companies, and that insures the directors of those companies. So the moment, and that's been already a few years, that insurance companies realize that, well, there's an emerging risk there, there's an emerging opportunity also to sell policies, then you also see the system changing and responding. So I think that that's already happened, and that in itself creates new impacts, and I think generally it has been a positive one.
So you mentioned insurance companies. So have you seen insurance companies start to look at insuring climate litigation risk, or is it more insuring climate risk more generally?
Both, yeah, no, and there's a super interesting case on the insurance of climate litigation. It's a case, so you know those many cities and states in the US that are suing the carbon majors. One of those cases is in Hawaii. So Hawaii is suing one of its oil companies, energy companies, and the energy company then wants the insurance company to pay for the litigation costs. As you know, it's not cheap to pay for a very good lawyer. So the company hires expensive lawyers and wants the insurance to pay for those costs. The insurer says no, and the oil company then sues the insurer. So that's already happening. Not only there's a question about that, but that this is in itself becoming litigation, which I always find fascinating. Also, that case gives an idea of something that is not in the public domain, which is the cost of legal fees. So we know it's expensive to litigate. You guys probably know better, but for us outside, there's no public data of how much it costs the company to defend itself in such cases. So this case says, we've already spent whatever X thousands, and it will cost millions. So you say, oh, there you go. The litigation is just defending yourself, not even if you lose, just defending yourself will be expensive.
Very interesting, thank you. Before we hand over, before we open questions up to the floor, there's just one last point that I wanted to pick up with you, which is on just transition cases. You mentioned this in the climate litigation snapshot, which was published last month. So if any of you haven't seen it, I would strongly recommend. Soft plug. So I think, could you tell us a bit more about what the just transition case is, and whether you think these regulatory regimes and these new requirements could potentially affect how just transition cases are brought, and what kind of cases you might see?
So I mentioned that paper with Annalisa Tavarese a few years ago. That paper, we started just wanting to map human rights-based climate litigation. And as we were starting to identify the cases, we came across this group of cases that didn't quite match what we think of rights-based, if you think of Shell case and other, or Agenda case. So these were cases that were being brought by communities, indigenous communities, or by workers, challenging policies that try to promote renewables, that try to, or development renewable energy developments. And so we were trying to map, and this doesn't sit in any of our categories. And the more we thought about those, we thought, well, actually, it's different. These cases are a slightly different story. They are cases that are not against, usually we would think about pro-climate, against climate. These cases were not really against climate. The groups, the individuals bringing those cases were not against, like saying, oh, climate change is a hoax and we don't want these cases, or this is going to interfere in our profits. It was not about that. It was about vulnerable communities that were already suffering in many ways, and that now have to also bear the burdens of climate policies. So the more we thought about those cases, we thought, well, actually, there's a name already for this. The name for this is just transition. This is an example of litigation of just transition, that translates the challenges of just transition. So we came up with this term, and academics, when we come up with a term, it's one of those days of glory. Yeah, we have a new term. We can create infinite ones, but not all are good. So this was a good one. And so we got very excited, and we said, this is uncharted territories. We don't know how many of such cases exist, because also they are usually not tracked by the databases. But let's say, we've termed them, and we stopped there. When we finished that paper, we started a new paper, and Ian is one of the co-authors. Yeah, there are so many authors that maybe more people here are. But we decided to bring a bunch of people together to define what just transition litigation is and is not. So one of the things that we discussed a lot is it only about human rights, or can we see just transition outside human rights? And the answer is definitely we can see outside. And so this paper that we conceptualized, which is also going to be published in Nature, which is very good news. We start with the example of a case in Norway where a group of Sami are challenging the construction of wind turbines in Norway, and they win. They go all the way to the Supreme Court and they win. And we say, how can we explain this? Who should bear the burden? And then we look into other examples of workers in Poland who are going to lose their jobs because coal is ending. And how are they being compensated? How are they being brought into the new industries? And so I think altogether, what these cases show us is that, well, first, it's not surprising. We know it's a complex issue, and complex issue requires complex solutions. And in between that, you find yourself with litigation like this. Second, I think they remind us that the transition to be equitable can't be resulting in disproportionate impact to communities that are already suffering. So I think it really becomes that reminder that, yeah, you're trying to do something great, which is climate policies. You're trying to do something great, which is increasing your wind and solar power, but what about those who are going to suffer? So I find it a very important reminder. And just last week, there was a new database that was made public by Business and Human Rights Resource Center. And I really suggest that you look in their website. They have identified 60 cases. Of these, the majority is actually in mineral mining, which we know is a super important, complicated issue, which now is going to be started being litigated under in some countries, and hopefully something that will do more research. And so there's now a bit more data, but I think we still have to explore more, and hopefully we'll do that. And then just to finish, in your presentation, you mentioned CSRD as having explicitly this concern about just transition. And we'll see probably more also just transition coming into climate legislation. And then what happens then is a bit of a mystery, because on one hand, by having that explicit reminder about just transition, potentially you could see more just transition litigation. But at the same time, now that's back to the story of climate litigation being a risk that is perceived by companies that they're more concerned about, you could also perhaps, maybe being very optimistic, hopefully, see changes and better consideration of these issues, and therefore less of such litigation, which would be a really big result.
Yeah, that's very interesting because when you're describing it, it drew parallels to what we've seen in quite a few green v. green cases, which are cases brought against climate action on the basis that some of that climate action might have adverse impacts on biodiversity and nature. And it sounds like increasingly now, and there are many more kind of sustainability considerations that companies and governments really have to navigate and balance. So, human rights and the just transition, climate action or biodiversity impact. So I think the case that I mentioned earlier about that the Indian Supreme Court ruled that climate was the right to climate was part of the right to life. I think that was actually a green case because we were looking at the protection of, I think it was the great Indian buzzard that was going to be adversely impacted by renewable energy development, and it's trying to balance, the right, trying to balance the state's duty to, or the state's intention to handle climate change versus protecting the natural environment, which is such an interesting, balancing act that, all these stakeholders now have to navigate.
Yeah, but definitely. And this year, our global trend report for the first time included the green v. green cases. So there's lots of nuance in these non-aligned cases, but also, I think the more we understand them, the more it will be, hopefully they will be avoided, but also it tells you something about the complexity. So yeah, I'm glad we included them this year. There will be hopefully more identification of them.
Watch this space. Now I think we'd like to kind of open the floor up to any questions from the audience.
We have a great online question, so I thought we might begin with this evening, if that's all right. Can everyone hear me okay? I'm happy to use the mic if needed. I think this is the first time I think strong online. Hello, can everyone hear me all right? Okay, fantastic. So Sana, who's attending online, has asked a question in relation to carbon offsets. So she says that many companies are adopting net zero commitments, and these often involve engaging partners to develop carbon offsetting programs in the short and medium terms. So do either of our speakers see any human rights risks related to these carbon offsetting projects? And if so, how might companies go about navigating these sorts of risks?
I can answer that one. So that I think human rights considerations and human rights risk in carbon offsetting programs is a major issue, and there have been quite a lot of concerns around the impacts that some of these projects can have on indigenous populations. So there are quite extensive frameworks where that kind of certify these carbon projects, and part of this is making sure that they have effective stakeholder engagement plans in place, that they kind of engage with the local communities and the indigenous populations in the area to make sure that to minimize the risk that that these adverse human rights impacts happen. In our work, we have advised on some of these frameworks, and we have quite a few clients that actually invest in these carbon offsetting programs. And this is always on the top of your mind because it's received so much scrutiny over the past couple of years. And there have been quite a few cases where clients would identify a human rights impact where they realize that their carbon offsetting program is in an area with a high risk of abuse. And what we've seen them do is take a very strict stance and look to pull out of the program, but while at the same time also mandating that the local implementation partner actually looks to remediate any impacts that may have been connected to the project. As we've seen, so this is clearly on the top of companies' minds.
Yeah, if I can just add, yeah, the question was, is there any risk? I think there are loads, and we're seeing them. We last year published a report where, together with colleagues at DNA Piper, where we try to identify corruption and integrity risks in climate solutions. So these offsetting programs fall into this idea of solutions, and I liked this separation between, one thing is climate action, and we talk a lot about more action and reducing emissions, etc. But then when it comes to the solutions, if the solutions are not credible, if they lack integrity, if there's corruption, then I think it's a double shame, because one, you're spending the money in those offsetting, and then that money is not going to the communities. Sometimes it's harming the communities, and it's harming the whole idea that you can have solutions. So it's a complete disaster, really. And this is why it's important to have more and better mechanisms to avoid these things. Corruption happens everywhere. I come from Brazil, you breathe, someone is already trying to bribe you for that. And so it's really important to have the understanding of where those risks happen and to reduce those risks. We're now working with the World Bank in a project to analyze different regulations on carbon markets. And this is going to be mandatory. Now we're talking about voluntary markets, but soon there will be mandatory markets. And we will need them to be, we need to trust them, they need to work, and we need also the authorities, police, international police, domestic structures that are able to monitor, to address, and to make this whole thing more credible.
Yes, definitely. And I think, and in quite a few jurisdictions that are significant exporters of carbon offsets, like Brazil, I think they are starting to introduce new laws around land acquisition to really, mitigate the risk of, an overseas company coming in and taking local communities off the land just so that they can plant trees. So there are efforts to try and improve the integrity of the market.
Thank you both so much. I think we should open the floor now. If anyone has any questions.
Thank you. I was just going to ask about what you said earlier about the inclusion of the Paris target of 1.5 as the in the standards. Earlier this year, there was an article by David Carrington where he found out from the vast majority of climate scientists that he talked to that we've likely lost our chance of staying under 1.5. So what does the inclusion of that target mean in that context?
Yeah, it's a very good question. And it's a question that we've been asked by quite a few companies operating in the space who basically ask the question, like, everyone agrees that so many people agree that we are not on track to hit 1.5. So why do we as a company have to try and set this target? And our the general advice, not from a legal perspective, but from a common sense perspective is, if you don't even try to hit 1.5, there's no way you're going to hit 2, and you'll likely hit 3. So I think that is the reason why regulators like the EU and stakeholders still try very hard to drive the ambition to push companies and push countries to set Paris-aligned targets, so that so to really kind of pick up the slack where other companies may not be as ambitious, and also build in that safety net, so to prevent us kind of veering into dangerous climate change territory. I hope that answers the question.
One more question over here, and I forgot to add earlier that if you have any questions, if you could just share a brief introduction to yourself, just your name or something when you ask the question, that would be much appreciated.
Hello, I'm Dominica. I work as a legal officer at Opportunity Green, which is an environmental NGO, and also on the stewardship committee of Legal Voices for the Future. So I guess my question is not very well formulated. Sorry about that, but it would just be really, really interesting to hear your thoughts, if you have any, on potentially the implementation of these new due diligence obligations that are coming into place, considering the fact that, of course, they're not absolute obligations. And on the one hand, there's going to be a role for lawyers to make sure that companies are meeting those obligations. But on the other hand, unfortunately, we are likely to see lawyers advising on how to, you know, wink, wink, meet those obligations, nudge, you know, and whether there's a legal pathway to kind of preventing that from happening. And yeah, thank you.
That's a good question. So, I mean, one of the key components of the due diligence requirements is communication. So that kind of feeds into disclosures. So in addition to actually creating these systems and implementing them, companies then have to report on them and show how they are, you know, the steps that they are taking to comply. And this, you know, creates the room for regulatory oversight, because each member state would establish a supervisory authority that is in charge of ensuring that the companies, you know, develop and implement these due diligence policies. And that also creates an additional lever for civil liability. So if you can identify that a company hasn't actually implemented these systems and human rights abuse occurs, that's the other avenue for, you know, the other hope to make companies comply. There has obviously, and I think as we said, has been discussion about the risk that this might really just turn into another kind of tick box regime. And I'm sure the regulators and the EU Commission are aware of this. And I think that's where the role of, I guess, lawyers and, you know, advisors come into play to actually, you know, advise companies not just on, you know, how do you know, do the bare minimum to legally comply, but really I feel like the advice that we try to give is, yes, you know, these are, you know, the bare minimum that you could do, but even if you do just the bare minimum, your stakeholders and your investors may not be fully satisfied. And that really like pushes the ambition up, so companies recognize that this is actually something that they don't have to do just from a purely regulatory perspective, but this is something that they have to do because their lenders want them to do it, their customers want them to do it, the shareholders that are putting money into the company expect you as a company to hold yourself to that slightly higher standard. And I think that's hopefully where the things will go when the CSDDD comes into force.
Thank you. I think we've got time for perhaps one or two more questions. So hands just here.
Thank you so much. My name is Emily. I'm from the International Bar Association, and found your comments about like what you see the role of lawyers in this space, in this sort of face of all this changing regulation. So interesting. I'd be interested to know, and this sort of speaks to Joanna's question as well, like on the ground, are you seeing clients wanting those that advice now? Has it really sort of changed your practice yet, or is this something that you're seeing more like in the future?
So it's definitely started to change our practice. For the past 6 months have been very heavily focused on the CSRD. I think we've been like the team's been kind of living and breathing on the CSRD, with lots of clients starting to realize that they actually have to report next year. So they are laying the groundwork and doing these assessments to actually get all this data that, you know, they previously never had to report on, or they may have had, but they're just scattered all over the business. So I think the role of, you know, regulatory and compliance lawyers have really started to shift to take into account these incoming regimes. And clients are also quite, I think with the CSDDD, a lot of companies have been quite concerned about what this might mean for them and their exposure to liability and, how do you actually implement these very extensive requirements that no one's ever had to do before. So I think we've been working quite closely with consultants to help clients recognize what their obligations are and actually start to develop the systems and processes needed to comply.
I think we have time for just one more question. This is the time that I go up.
Thank you. My name is Victoria Rogers, I'm associate at DLA Piper. I had a quick question, probably more for you, Joanna, about the trends that you're seeing and who is bringing climate mitigation, what that might mean for future risk. We're obviously seeing a number of class action fought on behalf of citizens of a given state or groups of NGOs, INGOs, etc. But what trends are you seeing in who is funding mitigation, where litigation is coming from, and what that might mean for the overarching risks for both states and corporates?
So you're asking not only the actual plaintiffs, but who's funding?
Exactly.
Okay. Yeah, because I think the first point I was going to make is that of course, when we think about strategic climate mitigation, we think about the NGOs and the individuals, the old babies and people who are, bringing those cases. But there is quite a significant and increasing number of cases that have been brought by companies who didn't take them long to understand that maybe they can also use litigation. And so we are seeing in this last report, we talk a lot about the anti-ESG movement and Shell and Exxon filing cases against NGOs, etc. So those cases are, we know who's funding and what's driving. But the cases brought by individuals and NGOs, it's an interesting and important question. So it's a combination of sources. First, there are cases that are crowdfunded, which is super interesting because you see how individual citizens would fund NGOs in general to do their work, but then increasingly you see individuals who are willing to pay lawyers to bring cases. And Planet Earth, for instance, has a lot of those. They have the famous rock stars, but also individuals. There are, of course, the philanthropies that have changed significantly this space because they have invested what nothing compared to what the companies can pay the law firms, but still they have invested more than what existed before and brought together a movement of lawyers, many of them who left the big law firms and started thinking about creative cases. It has been an area that has allowed for a lot of creativity, which other than this last part of today's session, often is not part of the day of lawyers. So, lawyers being offered an opportunity to think about an exciting case that has brought, I think, many lawyers who not being paid as well as they would in big law firms accepted to move. And then finally, something that we haven't seen much, but there is an idea that it will happen, which is investors. That's not unusual that you have investment in litigation, usually in class actions where the investors believe they have a good chance of winning and they will take part of the money, so it's an actual investment. There is a discussion or an appetite in principle for more of such cases, which I find an interesting bet because by the time you get the companies to actually pay, it will take a lot of time, effort, and risk, but there is also a potential for that type of funding.
Great. Well, thank you everyone who asked questions, and apologies if you still have them. I know that I definitely do. But just so we have enough time this evening for the creative content, I think we're going to end the Q&A session now. Thank you to everyone, and thank you to both Jon and Joanna for sharing all of your insights and thoughts this evening. We're going to break now just for 5 minutes, just to get some more energy, perhaps get some water, the bathrooms, which are just to the left as you leave. this room and we'll come together in 5 minutes time to begin the content part of it. Thank you. Yeah, We're going to now switch to content. Thanks for all your engagement so far. Final part of the evening, but often my favourite. So without further ado, I'm going to hand over to Jon, if that's okay, just to give a really quick introduction to our creative content. But aside from that, I think we'll be ready to hit play and move into breakout groups.
Hi everyone. So for today's creative content, I chose a short video called Blooming Cities, which talks about a local movement in Pakistan to rewild parts of Lahore, which is one of the world's most polluted cities. One of the reasons why I chose this film was because I was looking for a bit of creative content that featured voices from, the most affected communities in, places in the global south, which are often excluded from the climate conversation. So I thought this short film, which is only 5 minutes long, is a good example of showing how local ideas from impacted communities can provide local solutions to global problems. I hope you enjoy the show.
When I was growing up, Lahore was called the city of gardens. And all through my childhood, our family outings were about long walks and picnics in places which all had this thick tree cover that you don't see in Lahore after all. Lahore is this beautiful historic city. For centuries, it's been the cultural center of Pakistan's Punjab province. I always felt this innate connection to nature and found it fascinating to think that we once coexisted with other species in the wild. As we became more isolated from nature, we started to disrupt certain natural processes that are inextricably linked to our own well-being on this planet. About 10 years ago, suddenly it became so difficult to navigate through the winter months because of all the pollution and the new phenomena that we now know as smog. It is mentally and physically exhausting when you're struggling to navigate through the traffic and the visibility. In fact, Lahore was just declared the most polluted city on the planet. We have this huge urbanization taking place in the city. Lahore isn't alone in it, it's happening everywhere in the world. And then we have the rising industrial and vehicular emissions and crop residue burning already harvesting from them. I wanted to do something to help make a difference. Our technique of afforestation actually offers an effective solution to curb airborne pollution. Because we plant our saplings in the ultra-dense Miyawaki model, permaculture forests have an important role in taking care of the effects of climate change. And with more and more people now living in towns and cities across the globe, it is exactly where we need our forests to be. So how do we do this? We need to build these green corridors, we need to have more trees around us so that we can have the same ecosystem services right next door, right in our environment, in our current habitat. Because what we're trying to do is indeed bring back the lost forests. In other words, rewild our communities, rewild our neighborhoods, take care of our soil health, make it breathe, be alive. Only 3 years ago, people used to say, what are we going to achieve with these small patches of forest? And I would ask them to think about these forests not as isolated pieces of vegetation, but in fact as community permaculture gardens where people can be the stewards, grow their own food, and keep our soils fertile. What we started in October of 2018 has now taken the form of a movement all across Pakistan. Everyone can play their part in this transition. Rewilding can start in the backyard, move across the neighborhood streets, and blossom into the new city. My name is Bilal Chaudhary, and my dream is to see greener, wilder cities everywhere in the world.
Okay, we'll now move into our group to discuss the creative content. I think it would make sense to roughly split the room into 4 groups. So we have naturally divided in the middle, but if we could also divide halfway down, perhaps move your chairs if it's easier, if not, just kind of gather round. And if our facilitators could please just quickly stand up so we know who you are. Logan, thank you again. And yes, just fill yourselves out as you think fit. Perhaps a couple in each of the groups would make sense, or at least one facilitator would be great. In terms of timing, I think we'll have around 15 minutes to discuss, but we'll give you a warning. We've only got a few minutes left just to wrap up your thoughts, and then we'll reconvene just for some closing remarks and yeah, perhaps to share a few thoughts that have arisen during that discussion. Thank you.